In this component, we're going to look at the FDA Inspection Authority, where that enforcement authority comes from, how those inspections work, and this really gives us an opportunity to compare what we've learned about the Food Safety Inspection Service inspections, how those work, and the enforcement authority there, and to start to think of these two agencies, how they work and how they're different. And if you've been in an FDA regulated facility, a lot of what we'll talk about in this component will be quite familiar. But as we get into the final component about challenging inspection and enforcement authority, that'll be something hopefully that is new. But if you're in an FDA regulated facility, I think a lot of this will be familiar. So we always begin with the statutory authority and then go down from there to see where this power to come into a facility comes from. And so we have two primary sections in the Food and Drug and Cosmetic Act that we're looking at. And we're looking at Section 301, which gives us the prohibited acts. Those things during the inspection they're going to look for. And if you look at our syllabus, you start to see what that looks like. And you see next week we're looking at adulteration, and the week following at misbranding. And the other section is Section 704. And reading the history that was assigned, we start to see when this inspection authority came to be, how it wasn't originally part of the Act, and how that shapes what we do. There are two primary guidance documents that they're not rules, they're not from the statutes, but they're internal guidance documents that provide the FDA a structure for how to conduct these investigations. And one is solely focused on investigations, and that's the Investigation Operations Manual. And the other is the Regulatory Procedures Manual, which is a more broad document, a guidance document looking at other areas. But what we see from this total framework is two things. One, we see that this enforcement is completely discretionary. The FDA is not compelled to come into a facility, and it's not compelled to inspect, even if there's third-party pressure. A consumer watch group, for example, that really believes a certain facility shouldn't be inspected. It's at the discretion of the FDA to come and inspect. And it's also completely random. There's no schedule for the most part for when these happen. And when you hear the FDA discuss this, you'll hear them talk about two types of inspections. They have the for-cause inspections, and those are during a recall or an adverse event. They're investigating what happened and why this outbreak is occurring, for example. And during that process, they'll look at the entire chain of a particular product, from the ingredient supplier down to the grocery store, to look at where in that chain the problem arose. And during that inspection, if there are other issues that come up, those will be noted as well. And so those are for-cause inspections, and we can get some predictability around that type of area. If we know there's a particular investigation going on, then we can expect an inspection. But otherwise, we have what the FDA calls surveillance. And these are just completely random inspections. If you're an FDA registered facility, it's supposed to occur on a schedule, but there's not enough manpower for that to happen. And so some facilities can go 5-6 years, maybe longer, without ever seeing FDA boots in their facility. And some facilities, as soon as they're registered, it just seems, it happens that as soon as they come online, these inspections happen. And initially, the FDA authority to inspect wasn't there. And it wasn't until we had the birth of the modern Food, Drug, and Cosmetic Act that we had this inspection authority. And that was in 1938, and that created our Section 704 that provides this authority. But the Form 483 that we'll talk about today really wasn't around until 1953. And in that assigned reading on the history, you can see the intervening acts in between and what kind of caused and created this to happen. But it's important to remember in 1906, when the Pure Food and Drug Act passed, there was 5 pages of material. That was the entirety of the FDA's authority, was 5 pages. And so the FDA could go to a facility and ask to come in, but if there was a refusal, if something like that happened, there really wasn't any consequence for it. It wasn't a prohibited act at the time. So this inspection authority was really important. And the factory inspection amendment was also important because once the FDA gained that authority to come into the facility and to inspect, they would just leave, and then if there was an issue, they would just go ahead and take enforcement action. There was no notification, no opportunity to correct, nothing like that. The FDA would come and inspect, and then they would leave and suddenly there would be a seizure or there would be some other enforcement act. And so for this Form 483 was really important because when the inspection ended, it required the FDA to come and to provide that at least notification to say, here's what's wrong and here's the enforcement action we're going to take. So these amendments are really important because they provided the FDA the authority to inspect, but they're also really important for industry. It was the first time industry was given some rights and given some clarity about how this inspection authority was going to work, when it was going to happen, and what the process would be. So if you've been in an FDA regulated facility, this progression of events will seem very familiar. If you haven't, this is the progression that we take from the FDA initially coming into a facility to actually taking an enforcement action, that list of enforcement actions we've discussed. And there's a step before this that's required in the Act where you have the FDA agent is required to identify themselves and provide their authority to come in, and that's called a Form 482, and that immediately precedes the inspection. Inspections will last anywhere from 2 days to 7 days. If it's a for-cause inspection, you can expect it maybe even to be a couple of weeks. But what happens during that Form 483, that's the field investigator's opinion about significant violations. Minor violations they're going to discuss with the facility, but it's the significant violations that they're going to put into their establishment inspection report. At this point, it's solely the field investigator's opinion. Some field investigators are very experienced, some are new to a particular topic area, maybe coming from medical device into food. So this always goes to a compliance officer or a district director to review and to make a determination of whether or not the evidence that is there of the observation supports that it is a significant violation. And they also take that opportunity to decide if it is significant enough that it needs to be taken a step further and put into a warning letter, and that warning letters we'll see is sort of the final marker before an enforcement action is taken. There is an opportunity to respond to the Form 483. Some facilities will take this on themselves to do. Some will hire counsel to respond on their behalf. And that response is really important. There's a small time window to respond, 10 days to respond to the Form 483. And it's really important because it provides your side, the facility side of the story. And so when the compliance officer or the district director is reviewing that establishment inspection report and making a determination about those issues and whether they warrant a warning letter, they have this balanced view from the facility about what has happened. So it's not just about getting a response in, but what I always tell my clients is about getting a quality of a response in. But this is overall the inspection time frame, inspection arc that we'll see. Now, we have a lot of differences from when we're talking about the USDA inspections, which are continuous, compulsory, those mandatory inspections, and we know where to find those USDA agents. We look in our facilities, and there on a day-to-day basis, we see the Food Safety Inspection Service. But as I mentioned, some of my clients have gone several years of operations without a for-cause inspection, without having any issues, and not having a surveillance inspection either. So where are the FDA in those intervening years? And the FDA is broken into 5 regional offices and 20 district offices. And this is another reason when a field investigator does make it to a facility, it is going to be a detailed investigation. It's going to be a detailed look at the facility because in some cases they've driven several hundred miles to get to a particular facility, and they're going to take their time looking to see what potential issues are there and to look for compliance with the Act and the regulations. But that's where the FDA is, and that's the difference as we think about these comparisons between the FDA Inspection Authority and the USDA inspections. So as we mentioned, Section 704 provides the authority, and this is important because we need to look at the language of Section 704 to determine what are the boundaries for this inspection, and we have to ask, is that inspection going further than what this text is providing in Section 704? And so Section 704 permits the physical inspection of the facility, and it's pretty broad. Equipment, products, any labels that are there, any products that are waiting to be shipped out, any ingredients that have been received. But it is silent on records, files, and photos. And it's also silent on interviews. There will be some conversation with the investigators. There's a request for an affidavit that's pretty common, but those things are not provided for in the act. And so we'll see in the third component where that challenge to those requests for records and those requests for files and photos and things. There are some records that are provided for, but in the most part, like sales records and financial records, certain limitations are put there. But for the most part, records are off limits. What we also see is that in the companion section, that denying access to the facility and sometimes even to records where the agency has this authorization is grounds for prosecution. It's a prohibited act not to allow the FDA into a facility. And where we're seeing a really interesting intersection of this authority occurring right now is with foreign inspections. Now, it's no question when the FDA comes into a U.S. facility that this statutory provision, this statutory framework governs, and that if you do not allow the facility in, you refuse them to come in, or for example, they come in and they want to take samples, either physical samples or swabbing samples, and those are denied, that's grounds for prosecution. It's grounds for a warning letter. But then when you get into these facilities that are in Europe, in China, in India, what framework applies? When you register your facility with the FDA to say, I am a food facility that will bring food into the United States, and I agree to be governed by the FDA and the Food, Drug, and Cosmetic Act, there still is this interaction between two legal systems of how does this work. And I can provide you a link, but there are a couple of warning letters in the past year, both coming from a Chinese facility who initially refused the FDA to come into their facility, finally agreed that they could come into the facility, but then when the FDA wanted to take samples back to the United States for testing, there was a refusal. They agreed only to the extent that a Chinese lab could be used for the testing. And I think in particular they did want to use their facility lab for that testing. And the FDA went ahead and issued a warning letter, but they haven't taken any further action from that. There hasn't been a prosecution. There hasn't been a seizure. The one enforcement action they did take was to put an import alert, which meant that their products could still come into the United States, but there was a longer time at the border. So it's very interesting to see where this refusal of access plays and that disparity and that difference from a domestic facility experiencing this statutory framework and a foreign facility experiencing it. So again, I mentioned this briefly, but there is some access to records, and this is a quick list. There's some caveats with each of these categories that it's important to pay attention to. But for our purposes, it's good to know that there are some constraints in the statute, and there are some records that they can access. The major constraint that we'll see that the FDA must obey is that it has this reasonableness constraint: reasonable time, reasonable limits, reasonable manner. If the FDA shows up at midnight on a Saturday and you refuse, there's a basis to challenge that, and we'll get into that in the third component. But if they show up at 9 a.m. on a Tuesday morning asking for access to inspect the facility, and they're following the inspection manual, they're following the regulatory procedures manual, then they have every bit of authority to be there. So this is one of the constraints that they have, but it's not one that we see challenged much because there is these guidance documents that keeps the FDA inspection process pretty routine and pretty uniform across the nation. So some of the enforcement tools that we can talk about are actions that the FDA can take when there are violations, when there are these prohibited acts. And really, for our purposes now, we don't need to get into specifics about those, but we're talking, if we look at the syllabus, we're looking at food additives, food coloring, adulteration, and misbranding. If they find any of those three components, then they can issue a recall. They can put an injunction to stop the distribution of those products. They can seize those products, detain them. They can suspend a facility's registration so that they no longer can continue to operate, or they can seek civil money penalties through a civil suit, or they can actually go for criminal prosecution. A lot of people don't think about it, but the warning letter and the Form 483 itself, and the readings are clear in this, that these are enforcement tools. They're very difficult to challenge. They oftentimes conscript what you can do. They either ask you to remove a product from a sale, to change a label, to change an ingredient. There's very specific requests in those, and they're very difficult to challenge. So in essence, they do become enforcement actions. And so I add them to this list, but you may not see that commonly listed in there. And what I've also included, each of these has a definition and some examples, and the FDA has a sheet that they provide that provides all the information you would need on what each of these are about. And so I've included that with the PDF of the slides, and you're welcome to review that and refresh yourself on what some of these mean. Now, for our purposes, we have only 6 weeks, which isn't a lot of time, and I need to be able to make this course as practical as possible. So one of the things that I wanted to do is to give you a Form 483 and to provide you an opportunity to respond to a Form 483. If you haven't done that, if you haven't worked with counsel or you haven't worked with the FDA in responding to a Form 483, this is a really great exercise to engage in. And because we don't have a lot of time to be able to get into the prohibited acts before we can get into the Inspection Authority, I want to make sure that you can get some examples of what this will look like, what the Form 483 typically contains. And what's really interesting is I provide this every year for my clients because the FDA in February, January will put out for the prior year their enforcement statistics, and they look at how many Form 483s were issued and what the common observations were. And you can look on that list, and it goes all the way from the number 1 observation down to, I think it's somewhere around the hundreds. And it's only been cited 1 time, but number 1 has been cited like 200 times. And you can see every violation that has been issued. And what's incredibly interesting, as long as I've been practicing in this area of law, the top 10 list has not changed. There are always these top 10 observations. Sometimes what was number 5 will now be number 4, but it's always that same 10 observations. And so I want to make sure that I give you these not only as a way to be practical and give something practical from this course, but also to give you a sense that what a Form 43 looks like and where you can go and find what I'll be pulling from for the Form 483 that I will give you for week 2's take-home assignment. And so a lot of these relate to good manufacturing practices, excluding pests and these kind of things. So, many of these will be familiar for you if you've worked in these facilities, and if not, you probably have heard about some of these working in the industry. And so that's what these 2 slides are, and you're welcome to review these. And also, if you need help finding the full enforcement statistics, feel free to email me, and I can give you that link so you can look at all the observations possible. I also want to make sure that if you haven't seen a Form 483 that you get a sense of what it looks like, and not only for your own purposes to see how the FDA starts every enforcement action. This will pretty much be the basis for 80% of the enforcement actions. Those that are for cause that start with a recall, for example, will still have a Form 43, but it won't be the very first document that kicks off the enforcement process. And I also want to give this to you because this is what this take-home project will look like. I will give you a Form 483 that's going to include some observations, and I won't spend time here talking about the expectations there. I will have a separate video that will go through the expectations, but I did want you just to see what this looks like and to see some of the components. And 2 of the components that I want you to look at is that underneath each observation, for example with observation 1, it says all reasonable precautions are not taken to ensure the production procedures do not contribute contamination from any source. This is the formula for every Form 43. Immediately following the observation, you have this abbreviated language from the code and the Code of Federal Regulations. And these are the rules that the FDA is enforcing. Every time they make an observation, it has to be a significant violation of the Act. And significant violations of the Act are either going to be statutory language or they're going to be administrative rules that are interpreting the Act. And so if you go to the enforcement statistics component that I mentioned, you can look and you can find each of these abbreviated components and see which CFR section this is referring to And you can also see how many times this has been observed. Is your facility getting an observation that's, out of left field and not something that's cited very often, or is it in the top 5 or top 100 list? And immediately following that abbreviated code section is an application of the rule to the facts at hand. And it's looking at what the investigators observed in the facility and how that observation, how those facts in the facility make this a violation of the rule that they've cited. And so that's the two most important components of this type of document that you'll see. Typically at the bottom you'll see it signed by 2 investigators. This was a for cause. You may have been familiar with the Diamond Pet recall that was going on. This was a for cause, Form 483, that was part of the investigation. So there was a whole lot of investigators at this facility trying to figure out what was going on, and that's why we have so many signatures, but typically 2. And another document that you may see with this is an affidavit, and the affidavit is asking the facility owner to attest to certain facts that are in question or certain facts that they want to confirm. So from the Form 43, as I mentioned, we next get to the warning letter. And the warning letter serves several purposes. It's a bookend in a way before the FDA takes official enforcement action. And it's a way for the FDA to go to court and say, look, Your Honor, we provided the facility an opportunity to correct these issues at the Form 43 phase. We provided them notification that these were issues in the warning letter, and they're still not corrected. They're still not taking steps. And then it gives them that authority to go ahead and take enforcement action. If it needs to be judicial, they can take it. If it's challenged and they end up before court, they have that justification for what they did. They're completely public. You can go onto the FDA warning letter database and see based on category and type and search. And a lot of consequences flow from them being public. And one that has been noted for very large facilities is a drop in stock price. Anytime a FDA warning letter is issued, there's a corresponding dip in stock price. So that's kind of something that's interesting. And once it's up there, it's up there. There's no ability to remove that FDA warning letter. I've not seen that happen. So it's something that stays kind of permanent. It's pretty much appropriate for most violations. You'll typically see it go from the Form 483 to the warning letter to the enforcement action. But as I mentioned, if it's a for-cause investigation, then you may see it go from a recall to Form 483, and you may even skip that and just go from a recall straight to a warning letter. It provides 15 days to respond. Typically, at this stage, counsel is involved, and the facility is working with counsel to develop a response and to talk about how things are changing and what's happening there. And again, that 15 days to respond is an ability for the facility to tell its story and to stay any enforcement action. And it does take time. From a Form 43 to a warning letter to enforcement action can be a couple of years, and that is a critique of the FDA process that varies from the USDA process that is much faster. The FDA does take time, and so it's good and it's bad. It depends on what your perspective. If you're looking from a consumer perspective, if you're looking from a facility perspective, you have different feelings about that, but it does take time for the FDA to respond, and so it is important to look at. So hopefully this has given you a good sense of what the FDA authority to inspect is, how that authority plays out in these inspections, and some of the enforcement tools that are available. It also hopefully gave you a little insight into what this take-home assignment will be, and as I mentioned, there will be a separate video that will go over that take-home assignment and the expectations for what that should be. And what we'll look at, I think in the next component will be more interesting. We'll look at the actual ability to challenge these enforcement actions and get into the meat of what our reading was for this week.